So welcome everyone to the fifth session here at the Berkeley Center for Law and Technology's program for student athletes, program for student athletes' families, and for administrators across the country. We've been focusing for the last four sessions on immigration and NIL, how to protect students, which is, kind of what we're really all about is providing protection for students and advice for students that maybe don't have access to, access to lawyers who don't know they need to go out and ask for help. So there's a lot that we're being able to provide in this kind of program. And in many ways, I'm along for the ride and learning too here from BCLT. Ksenia, one of our alumni, I have to put in the plug for Berkeley Law, created this entire series and has been directing it, and just really donated a lot of her time to help students nationwide. So I try to get out of the way quickly. Ksenia, thank you again for putting all this together. Once again, I'm looking forward to what you have for us.
Thank you very much. Well, this is originally was planned to be the last session, but I think we're going to do one more with some folks from athletic departments. So I will put that together, and we'll be handling this issue from that institutional perspective as well. But today we've got a bunch of lawyers in the room, and this is a really great panel for me because these are my assets as I advise on NIL issues, as I keep my finger on the pulse, so to speak, about the latest and the greatest in the NIL space. And I have the pleasure of being here with Amy Maldonado, who is my partner in NIL crime, not literally, obviously, but she's my co-author for the NIL and immigration book. Amy and I are kind of the industry perspective. Professor David Weber is obviously the brainiac academic among us, and offers a far more measured perspective than some of us tend to look at. And John Mazzeo, who is with Vertical Screen, is a person that I'm really pleased to bring to the table because he really has a handle on the compliance aspect of it. And in fact, as we talk about some of the issues that are on the agenda for today, as we delve into this idea of international student athletes being classified as employees, John was actually the person who personally brought this idea of, well, what is it going to look like from the institutional compliance standpoint to my attention. Prior to that, I think Amy and David and I have been having conversations about NIL and the idea of direct payments only from the student athlete perspective. And what John brought to me was, wait, well, we have an I-9 issue that we need to think about. And we're going to kind of dive deeper into that. But before we do, I kind of want to ask maybe Professor Weber can take us through in just broad terms of the two buckets of money under the House settlement. So we have the sort of forward-looking direct payments, and we have the more backward-looking NIL component. Can you just walk us through how that works under the House settlement as we know it under its current terms?
Sure, thanks, Ksenia. So the backward-looking component of the House settlement is really akin to back pay. What the athletes are claiming is that they would have been able to make money from their NIL rights prior to July 1st, 2021, if the NCAA had not had a rule in place prohibiting that. So there's a 4-year look-back period that they're claiming for all of those rights that they would have made, but for the NCAA's improper rule regarding that. And I think that's pretty straightforward. It's for work that's already been done and rendered. It's for these athletes that were on those rosters prior to 2021 for those 4-year periods. Going forward, the prospective portion is the direct compensation piece. And this is really unique in the world of the NCAA because we've not before ever seen universities making direct payments of cash to athletes in more or less a quid pro quo type of situation. Now here the quid pro quo is said to be direct compensation for NIL rights. And so the universities are going to be able to pay somewhere between $20 and $22 million per year to start to all of their athletes kind of across the board. And they're going through some very interesting discussions now about how they might go about allocating that. But I think for our purposes today, where we're very interested in that is looking at the international born athlete who is going to be competing on these teams, who is typically present on an F1 student visa, which is going to have some significant limitations in what kind of work would be allowed. And so I think really the issue with these prospective payments is whether or not they can be designed or formatted in a way that they're not deemed to be compensation for work. And we'll talk much more today about kind of the difference between an employee versus an independent contractor. What might be work under one statute might not be work under another, but really those are the two main buckets going forward.
Very good, very good. And I think I want to return a little bit later to, some of the discussions that are happening at the institutional level about some ideas about how these funds might be distributed, whether they're going to go to all the sports or whether schools are going to focus on only revenue generating sports and what the implications are from our perspective, which is the immigration perspective in all those scenarios. But before we go in that direction, Amy, do you want to take us through the NLRB decision in Dartmouth and kind of give us the very nutshell version of what that was about?
Sure. So basically, the NLRB ruled against Dartmouth University and found that the men's D1 basketball team, I believe it was, are in fact entitled to unionize. And one of the issues that was raised in that case, Dartmouth University raised the issue that international students don't have employment authorization and therefore cannot be employees because they'd be in violation of their status. And in an extremely irritating decision, they said, well, just because you're a member of a union doesn't mean you're violating your F1 status. And that's not super helpful because if you're unionizing, it's because you're an employee and employees require work authorization. That's the nutshell version. So my understanding is that Dartmouth is appealing that case, but I think we all agree that the writing's on the wall and we're headed in the direction of student athletes are employees.
And for our purposes, the reason why that's problematic is because these students are on F1 visas, as we've been talking about, which comes with employment authorization in very limited scenarios. Most likely none of those scenarios is applicable to this direct payment situation. So, John, I want to kind of take it to you to give us some background on how this all interacts with I-9 compliance. What is I-9 compliance? What is Verify? How does that play into this issue? And what should schools be thinking about as they consider the structure of their house settlement payments or other direct payments arising under perhaps some of these new state laws that have just been signed?
Yeah, Ksenia, it's a great point. And, I think one of the fun parts about the immigration law for me has been how it interacts with everything. If you told me 10 years ago, maybe 15 years ago, when I was working in athletic communications to put myself through undergrad, that I would be talking about this topic in this role, I would have laughed hysterically. But, I know every employer since November 6, 1986 has to complete Form I-9. Form I-9 is supposed to ensure that you know who you're hiring and that the person you're hiring has work authorization. And once you become an employee, and it's not only employee under the IRS designation or some other designation, the statute itself and the Code of Federal Regulations at 274A.1 defines employee as essentially work for some sort of remuneration. And that's why, Amy's recitation of the NLRB decision makes so much sense, because that, one of the arguments, and I think Amy, correct me if I'm wrong, that Dartmouth put forward was that, well, we're not paying them. They can't be employees. And, the first one is, well, you're being compensated. Remuneration doesn't have to be cash compensation. It could be tuition. It could be room and board. It could be, the NLRB a judge went so far as to catalog what the value of the free gear that a Division I athlete at Dartmouth receives and count that as remuneration. So it's very clear that these folks are employees, regardless of what stretch of the imagination, how you get there. Form I-9, every employee must have an employer. The employer must complete Form I-9. You can't complete Form I-9 if there's not employment authorization there. And then you run into the issue of, can I actually employ this person? So, the way I'm looking at it and the way I'm speaking to others is really, okay, you have a student athlete, who is now designated as an employer because it's happening, whether it's through House, whether it's through the NLRB, which I think there will be changes, moving into the next administration, or whether it's individual states that are saying, we need our state institution to be competitive with the one next door. And the one next door is offering payments. So our legislature needs to authorize payments. It's happening. It's there. The cat's out of the bag, toothpaste out of the tube. The real issue for the employer, which is the athletic department, the university, et cetera, is how do I employ these foreign national athletes? And how do I get them on my books? We've struggled. There have been focus groups. There have been other groups that say, well, what provision of law could a student, work under and be able to accept employment for their athletic pursuits? And we have yet to find one. So you fail that first piece of showing employment authorization on the Form I-9 there. And then you run into that decision where, what does the university do? Do they advise the students, hey, here's your pro and con, individually? And I'm sure that's been discussed before where, okay, we can be a little loosey-goosey, or we can be take a liberal reading of this and shoehorn you in, maybe put you in a program, a sports management program, and say, oh, well, the act of playing is like a co-curricular activity or a co-op opportunity. That's one way to take it that has some degree of risk. The other is, do you just not have them on the team? And if you're the institution, the risk is bigger. The risk for the individual, the athlete, is what are my visa considerations down the line? If I'm a big time Division I athlete and I know I'm going to go pro and I want to be in one of the big 4 or 5 sports leagues in the United States, I'm thinking, what do I need to do right now to preserve my eligibility to qualify for a visa? And working, without authorization is not one of those things. As a university or an institution, I'm thinking, okay, I might have this coach or this administrator who's saying, we need this person on the team. They're the best player we have. It's free advertising, et cetera. But if I can't complete the I-9, there's a civil violation. And then I'm worried about, okay, well, if I can't complete the I-9 because I've determined this person doesn't have work authorization, I now have a knowing hire. And a knowing hire leads to a criminal investigation, a debarment, loss of federal funds, and really can be crippling for an institution that is reliant on such.
That's super, super interesting and also scary, I think, for a lot of institutions. But I'm going to go ahead and play law school exam with everyone today. We're going to add some new facts to our baseline scenario, right? And so, John, I'll throw the first one at you. And that is, in light of some of the conversations that I've been having with institutions, it seems that in general, for reasons having nothing to do with immigration, schools are really keen to sort of defer that point in time when they are treating their student athletes as employees, right? And they are exploring at this time every plausible scenario to classify them as independent contractors. So with that particular scenario, how does your analysis change, or does it?
So it really doesn't. The independent contractor definition for immigration purposes, for Form I-9 purposes, is close to the general definition. I think it's a little narrower. But the I-9 statute is very clear that you can't call someone an independent contractor because they don't have work authorization. It's also a similar issue to what a lot of the gig economy, companies are going to run into is, they're classifying everybody as an independent contractor and not asking if they have work authorization. So I think going forward, a more aggressive administration would really look to those sort of arrangements with a very, very, scrutinizing eye. Because in my analysis, you can't get around it. If you know that this person's a true blue employee, and really, if you're cutting them a check, I don't know how you don't call them an employee, and say, oh, well, we'll 1099 you, it'll be fine. That's not a viable option at this point.
that makes good sense. And you mentioned something about, sort of the posture, the enforcement posture of the next administration. And I think I'd like to ask Amy to chime in on that as a practicing immigration attorney who lived through the first Trump administration. Can you just speak to what we can expect in the larger immigration landscape in terms of this administration's enforcement priorities and how their enforcement posture might differ from the current administration and where the chips sort of fall for this particular scenario for universities?
So I think anytime you're in a gray area with regard to immigration, you are going to be looking at a decision against your client, because it's very clear that the people in the incoming Trump administration who are in charge of immigration want to limit both humanitarian immigration at the border, which is going through the legal process of asylum, withholding of removal and relief under the Convention Against Torture. But also what we know from the last go around with the Trump administration is they made more than 500 policy changes in the USCIS policy manual, and every single one of them was intended to make it more difficult to obtain legal status, more difficult to extend your status, more difficult to apply for non-immigrant visas abroad. They're going to have a very strong enforcement policy. I think the question that's going to remain to be seen is they're biting off a lot. They're claiming they want to deport 1.3 million people in the first year, while also ramping up enforcement with employers who are employing people who are not in valid status, and opening investigations, reopening people's citizenship applications to try to find grounds to denaturalize them, which they did last time. They had 800,000 citizenship applications under review that had already been approved that they were going through to see if they could revoke them. So it's definitely going to be a very hostile environment. It is not going to be the kind of environment where I would want to send an F1 student athlete out of the country and hope that it goes their way. I think we've all seen the emails, and I don't know if this is coming from Berkeley, but there was an email circulating from Cornell, and there are various institutions telling their students to be here on January 19th and not to plan to leave for 4 years. So it's going to be a very, very harsh climate. What remains to be seen is how competent and effective are they going to be at accomplishing all these goals. But I think it's again clear a lot of people are going to be harmed and suffer with regard to their immigration status. Probably not as many as the incoming administration would like to see, but it's not a good environment.
So just to kind of provide a little bit more context for that, a lot of what we've been talking about over the course of this entire series kind of hinges on two things. One is the positive exercise of discretion, right? When we talk about the consular interview, where the officer has broad discretion to deny you for almost any reason or no reason at all. What we are counting on in every instance when we work with student athletes who are using perhaps a workaround on their F1 or a student athlete who's already transitioned to an O or a P visa is that consular officer's discretionary analysis to land in their favor, for that discretionary analysis to support the position that we're trying to advocate for, which is that this is an appropriate use of the classification. And there's quite a bit in immigration law that really does involve discretionary analysis. And so one of the things that I think we all saw as practitioners under the first Trump administration was that to the extent that there was a discretionary option, that the policy was to limit the favorable exercise of discretion in almost all cases. So that is something that we have to take into account as we go forward. I mean, I think that a lot of institutions have been advising athletes from the posture of, well, let's get it done and ask for permission later because we're famous and we are whatever institution and this is whatever famous athlete. And I think that those kinds of strategies to push the envelope are perhaps going to be punished with some denials going forward. So that is something we have to keep in mind, that this particular administration is going to be much more enforcement minded, but that enforcement is also going to reflect not just in terms of, catching somebody who's blatantly doing something wrong, but also in the realm of, well, this is a positive exercise of discretion or a negative exercise of discretion. We're going to lean towards the negative side of that realm. So that is something that we have to think about. As we sort of discuss again, the way that the distributions could go, the way that the distribution of funds could be structured, we're all talking about the employer versus non-employer scenario. I think, again, from my conversations with stakeholders, it seems to me that most everybody, again, for reasons unrelated to immigration, wants to treat them as independent contractors, and the plan for most schools is to enter into an agreement directly with the athlete for the payment of funds. Now, there's a significant amount of variation between schools as to the terms of those agreements and what they're thinking in the distribution side of things. So, there are schools that are only considering distributions to revenue generating sports, which I think, outside of the realm of our discussion today, but could potentially raise some Title IX issues, and think they're smart attorneys trying to work around that and figure out how to make things work, right? But for certainly a number of schools that I've talked to are really focusing on men's and women's basketball plus football as the rosters that are going to get, most, if not all, of this money. So I'll go to each of you, and starting with Professor Weber. If we have a distribution where the money is being distributed in some way, and we're going to talk about, later the nuance and how, but between only athletes on the revenue generating sport rosters, what does that look like? Does that help? Does that hurt? What does the immigration perspective look like in that situation?
I think it's a really interesting question, especially tying back with what Amy mentioned earlier about potentially increased enforcement with international athletes. I think one of the common workarounds in the current era has been, well, we can always send you back home to engage in conduct there, whether that's shooting videos, photos, etc., social media, and that's a safe approach. But if universities are starting to tell their athletes or any of their international students plan on being here for 4 years, that's going to narrow that window then of a potential workaround. And I still think that universities, it's very early days still. I think most of them don't know exactly how this is going to look even as soon as next spring. But I think they're trying to figure out, is there a way to just say, well, paying an athlete is fine, right? As long as you're not paying them for work. It's not a problem as an international individual to receive money in the United States. And this goes back to the sort of the passive income versus active income distinction. And for the universities, if they're just saying, well, we're just going to give you money for essentially the use of broadcast rights because you're already participating in these games, we're not paying you for that. It's just this is being created and we're going to pay you for that. I could see a university saying that's really easy for us to implement, right? We still have to decide how to divvy up the pie, but just say we're going to compensate you pursuant to this independent contractor agreement, which really would just be a royalty agreement, right, for those publicity rights. So I think that would be potentially interesting. But again, it comes back to that distinction. Are they getting paid just for that passivity, that NIL right? Or is it coming back more towards what they're doing in practice on the field, on the court, etc.? And when we first saw all of these NIL cases arise after July 1, 2021, what I saw almost every university say to their international athletes was either, this is too unclear, don't do anything, or if you're going to do anything, get your own attorney and have them advise you. And of course, that's easy for the institutions to say because then they don't take any of the onus on them. So I wouldn't be surprised to see similar language going forward with these types of issues, saying if you're an international athlete, here's our compensation scheme. If you want to participate, you can, but you should know the risks going into it. Now, I don't know how that all ties in with the I-9 implication, if they are in fact working for this, or if it truly could be structured in a passive format that that could pass muster, but again, subject to the potential concerns of a more aggressive immigration service.
Okay, before I switch the scenario, John, do you want to speak to what are we thinking in, in that context? So revenue generating sports only are receiving funds under an independent contractor agreement where basically it is being styled as NIL royalties.
Yeah, I think it really going back to your point about discretion earlier, I think it all comes down to what this incoming administration, who is sitting in that seat, what they think, right? I might have one, and this is really an unsettled area where can I come to the United States and license someone else to take pictures of me? I think one argument is, yeah, it's passive income, big deal. I think the other argument is, well, you wouldn't be there but for your participation in the athletics. Because if that was the case, if this is truly passive income, then I would be taking as many pictures of the star point guard on the women's basketball team as I would, the pre-law student sitting in the library. Because that's, what I'm here for, right? So I think that's a first hurdle of how you get there. And one idea and something that I think is being talked about is, okay, what is this new administration going to target, right? I've had discussions with individuals in and out of government, in and out of large and small organizations who say, we believe that this administration is going to obviously not exercise discretion in a ameliorative way, but also is going to target certain universities. It's going to target certain populations. It's going to target certain states for enforcement actions. And that's as political as we'll get. But you have to think, right, if you're making that decision over whether or not a jump ball is going to go to the government or you, it's not going to you. And that's an undue risk at that point. And we've talked about other instances where individuals have come to the United States to have photos taken of them, and CBP has refused them entry because they've said, you're not coming here, to have this passive income. You're coming to be an actress. You're coming to be a model. So I don't see how that theory isn't equally as applicable here.
So I'm adding on to our law school exam, okay? Because one of the the wild cards in this scenario is who gets to decide how the money is distributed, right? So one of the scenarios that is being considered is X amount of that $21 to $22 million is given to the football coach to distribute as he sees fit. Now, my analysis on that is, okay, well, the football coach, if he's going to distribute money, is most likely going to give most of that money to the athletes who have the most athletic value, which is not necessarily equal to their NIL value. Professor Weber, what do you think of that? Do you think there's a distinction there, or?
I think for the most part, you're spot on, right? I think for the most part, if you're the coach, you're trying to win football games and not get fired, right? Try to make a bowl, try to win a playoff game to get a championship. And already I've heard conversations across various different universities where they are looking at a merit-based approach to how they're going to divvy up this money. Merit-based meaning, for the most part, you're going to pay certain skilled players a lot, and you might pay some other athletes very little to none from this compensation pool. And they're just trying to get the best return on their investment. And so as they're trying to, land a quarterback or a center for the basketball team, those are the kinds of decisions that they're making. And so I think that then goes in the face of calling it NIL rights, right? Based on your right of publicity. Because if it was truly based on their publicity, you would expect the coaches to look at how many followers do they have on Instagram or whatever social media channel. How are they monetizing that? What are we getting in exchange for our advertising buck? And I can almost guarantee you that conversation isn't happening, right? They're trying to field the best team that they can on the court or on the field.
And while there may be some correlation between the star quarterback of, you know, any given Power Five school and his social media following, there's most certainly somebody else on that roster who's not very gifted athletically, but who is a phenomenal content creator, has a great following, and, you know, kind of puts that concept of NIL value towards the idea of, you know, followers and social media, whereas that probably don't have a tremendous amount of value on the field. And if the money is being divvied up based on that athletic ability, that person probably will get less than every other player. So let me ask you all this, and Amy, I'll field this one to you. Do you think strategically there's any difference between saying, okay, we are only going to pay, you know, so the money could be divided in a way where ostensibly some players on the roster get nothing, right? Because they're deemed to have, you know, de minimis or no value, versus a situation where everybody gets a certain baseline. And then, you know, certain athletes based on their NIL value get more. Do you feel like either of those scenarios, like those scenarios, are distinguishable from an immigration risk standpoint?
I mean, I think as we all know, it's not about whether or not you get paid, because for many, many, many years, people have tried to evade the immigration laws on employment. In fact, I had a law student contact me about doing an internship with my office, and she was an F1 student. And I said, "Do you have CPT?" And she said, I can't use my CPT. And I was like, "I can't employ you." And she was like, "Oh, I just want to do an unpaid internship." And I said, "That doesn't work, because if a position is normally paid, then, you know, you can't get around that by being unpaid." So if everyone's unpaid, I think maybe you have an argument that the position is not normally paid, but then the international student athletes would be precluded from getting any additional money regardless of their NIL value, I'm thinking. And they also can't do anything. So it's not just what you get paid, it's what are they having you do? So are they taking photographs of you while you're playing basketball? That's fine. If you're already playing basketball, you know, on the team, and you're not a quote unquote employee, you're not providing services in exchange for remuneration, or providing services and foregoing remuneration just because you don't have work authorization. But I think the real issue is, you know, and I always tell my clients this, the statute was written in 1952. It's been chopped up and tossed in the air and reassembled like a beat poem. And, you know, we've had various amendments. And so what we have at the end is basically a set of laws that are antiquated. There have been very few updates in the 21st century to any of these laws. As you know, when you're sponsoring an employee, you still have to place Sunday print newspaper ads. So they have definitely not caught up with 2021 changes in NIL compensation. It's just not even on the radar. And that is very, very risky for international student athletes, and potentially for institutions from a liability perspective.
Mm-hmm. So I think, you know, what I was trying to get at is a few of the things that have been tossed around out there is, okay, so why don't we only enter into agreements with our, you know, domestic or work authorized athletes? And I think that's definitely a no, because of what you've already identified as a situation where if the position is typically compensated, then not compensating based on the fact that this individual is an international athlete doesn't help. Another option, and I've heard this from a number of institutions at this point in time, is this idea of, you know, saying, well, we're going to have the internationals do less, right? So we're going to really just limit their agreements to strictly royalties off of NIL, whereas the agreements with the domestic / work authorized students will look different in that they will include additional deliverables that may be a problem, that may be perceived as, you know, services, labor, employment, something requiring employment authorization, on the you know, if those things were to be performed by the the international student athletes. So my question to all of you, and I'd actually like to hear everyone's opinion on this, because I haven't really formulated my own in this area, but let's say they are doing that. Let's say they're saying, okay, the domestic students have additional deliverables, autograph signings, all kinds of other, activations, whereas the agreement with the international student athletes is for passive NIL only. What do you think about that, John?
So first, I think you have to get over the hurdle of what is passive NIL and is it not work for remuneration? But I also think, this is where our broad scope employment law issues come in, right? You have the first one of, okay, well, I'm going to treat these people differently, for what reason? Oh, because they're a foreign national. That doesn't really hold much water. And we've seen a lot of litigation surrounding DACA recipients in federal court. We've seen a lot of settlement agreements with the Department of Justice's Immigrant and Employee Rights group that say, you can't treat people differently because of their immigration status. So it's very hard to make that argument. And something we've been talking about in the undercurrent here is, regardless of how I structure it, the more I try to massage it and the more I treat one group different than another, or the more I sort of try to, make it not look like work, those are all factors that any trial attorney or any regulatory agency is going to hang their hat on. And when they when they make the argument that it is work, how can you not say this is work? Well, what's the difference? Why are you structuring it one way for this group and another way for that group? So I think the risk, of doing that, yeah, it might make sense from an immigration perspective, but you also have other freestanding immigration or employment laws that come into play, especially, with the new administration. I've been working on a number of different things. And one is the New York City human rights law. And I'm just throwing this out as an example, because this is also a tenet of sort of the other case law, is just because someone lacks work authorization doesn't mean you can discriminate against them. Doesn't mean once they're hired, you can treat them differently. So I think really in all of our discussions, once that first row on the house of cards goes down, the whole thing goes down with it.
That's interesting. What about you, Professor Weber? What's your take?
Well, if I were talking to institutions, I think I would start with, why are we having our domestic-based athletes do more? Why not just have everybody do the passive stuff? Because if you're worried about the deliverables, and when I've worked with collectives on these deals, the athletes are always happy to do less and get paid, right? They never want to do more. And if you're giving the athletes a choice between either you can get paid a lot and we'll just scrape videos and images from our media, or you have to come in and write out 100 autographs or post this many posts, I think all the athletes would prefer the former, where they just have to sign away their passive rights. And from an institution's point of view, if you're trying to avoid any concerns about pay for play and make sure that you're actually just paying for the NIL, if you already know what the deliverables are, you don't have to have someone checking to make sure that the athletes are following up on their duties, that they're doing anything more than just, did they assign those rights to you? And if so, you're kind of done, and you can make use of those rights as you see fit. From an institution's point of view, I think that's a lot cleaner and easier. So I would default then to say, for everybody, right? Whether I pay you more or less, I can differentiate based on the value of your NIL. Whether I pay you more or less, I still just want the same deliverable, meaning that very passive, the stills or the video from practices from games.
But to John's point, does that make it look more like pay for play?
I mean,
where's that line? That's what I'm not able to identify. Where's the line between pay for play? Because you are essentially, your only prerequisite to getting paid is you are on the roster of XYZ University, right? And so if we're saying that this is based on NIL value, then why aren't the other athletes at non-revenue generating sports also getting money, right? Because they're not generating revenue. I think that limiting the money to just revenue generating sports is actually a pretty dangerous way to go, because I think it makes it look more like pay for play. Amy, what's your take on this?
I definitely agree. I think, if you're only compensating people such that some athletes are getting nothing because they're not in sports that generate revenues, it's at least looking like clear revenue sharing based on, what the athlete is doing on the court or the field. And so that's a problem.
Yeah. And, all of us have been in conversations. We get together, I'd say, pretty regularly, about once a month, and talk about all these issues. And, with all our different backgrounds, so far, we've not been able to come up with the magic bullet that takes care of all of this. So, these discussions are valuable to getting some ideas, but certainly, there's nothing that we've identified at this point in time that is quote unquote safe, right? That is fully and unequivocally compliant from both the immigration law perspective and the perspective of labor law. And I think one of the really interesting aspects of this issue, as I've been delving more into the implications of direct payments and House and all of the attendant issues, is that where there's a solution from a labor law standpoint, there's a problem from an immigration law standpoint, and vice versa. And so I think this is a situation where those disparities in the definitions of labor, employment, and similar concepts really come home to create all kinds of practical issues for the universities. And so, I think the bigger question is, okay, well, if none of that works, what now? And that's a very difficult conversation to have, because I think fundamentally the answer is we don't know, other than why don't you as an institution try to leverage your power, your standing, to try to bring this issue to the forefront. And I think, Amy and I have talked a little bit about this before, but prior to kind of getting connected with John and really starting to think about this from the perspective of institutional compliance, we've been talking about NIL from the perspective of student athlete compliance. And that so far, I think, has been an impediment to getting the government's attention, because they feel like, A, it's not that many students who have the ability to make this kind of money. And B, if they can say, well, this is just one student and he can just wait to make his money until he gets in the NFL, NBA, MLB, whatever, then it's not a necessary fix, right? Whereas I think the conversation that we're having now, the tensions that we've identified between labor law and immigration law, and perhaps even with tax law, Title IX, all these things are demonstrative of the fact that we really need some level of intervention. We need a solution. And, so far, the four of us have been, I think, advocating, but rather ineffectively, for a solution. So I would urge institutions to leverage their voice and their power and their star athletes to actually try to bring some attention to the issue. But what advice, John, what advice do you have to institutions as we're sort of navigating this very uncertain landscape? And what are at least a few things that you think they can do to try to protect themselves to the best of their current ability within the existing landscape legally?
Right. I think, and the most important thing to remember here is that, none of us are in business if there is no risk. To exceed, to excel, to do well, you need to take risks. So the number one thing for universities, institutions, et cetera, to think about is, what risk am I willing to take? And how defensible is that risk? There are going to be some institutions that say, we are a very competitive institution. We want to have the best athletes we can on the field, and we're willing to take a lot of risks, because at the end of the day, we can survive. We could survive the audit. We could survive the fine. It kind of is what it is. There are other institutions that are going to say, no, we're calling them employees. If you don't have work authorization, if you can't complete Form I-9, we're not going to, put you on the team. And there's going to be trade-offs there as well. So the first thing you can do, especially in this state of uncertainty with an incoming administration that we don't know what we're going to get, or rather we know what we're probably going to get, is understand your risk tolerance, understand your risk profile. The second is you have to decide, okay, how do we best craft this given what we have? And I think all of the ideas floated here of, hey, it's not a revenue sharing agreement. It's a passive income. Okay, well, how do we structure that passive income flow to bring home to an adjudicator, to a court, to a labor board that this really is our, we apply this to revenue generating, non-revenue generating, men's sports, women's sports, USCs, lawful permanent residents, and non-citizens, foreign national students. So, that's the second piece is if we're going to go down this road, how do we structure it to make the best record for litigation? Because it's going to get litigated. Essentially, at some point, an institution's going to get a 9-9 fine. An institution's going to get a discrimination lawsuit. An institution's going to get sued by a former athlete who gets turned around at the consulate or the border. It's going to happen. So how do you make that best record for litigation if you decide to go down that road? And really, is everybody, on the same page? From the provost, or if it's a state school, the legislature, the chancellor, the provost, down to the athletic department. Obviously we have some large institutions where football has one or two athletic directors itself. Having that alignment, knowing we're all in the ship together, and there are trade-offs to be had. Those are discussions that we talked a year ago. Those are discussions that should continually be happening, especially as things change the calculus.
Yeah, Amy, what do you think? You're on mute.
I think I'm muted. I mean, that you and I have been working on this issue since 2021. I see risk everywhere. I see no solutions. I see no motivation to get solutions. When we've discussed this issue, kind of with various politicians, I know I've talked to some Republican politicians behind, closed doors, will say, yeah, this definitely needs to be addressed. We're not passing an immigration bill. So I don't even know. I mean, I feel like we're in a big problem and there's currently not a solution for this big problem other than basically kicking all the international student athletes off the rosters.
So I think that as we move into this new era of direct payments and the administration of the direct payments, some schools are already contemplating the expansion of staff, adding positions such as NIL contract negotiators, new folks to the athletic director's office, potentially, new positions under the umbrella of the general counsel's office. And I think that as schools consider those expansions, they really need to have somebody in-house or outsourced who understands these issues. And I don't think it's going to be one person, right? I think you need to be able to have multiple people in a room. And I think you need to have an immigration specialist talking to a labor specialist, talking to an I-9 specialist, talking to a Title IX specialist, talking to a tax specialist, right? Like all those people need to be at the table to come up with a solution that works from all perspectives. Because as folks who represent the immigration compliance side of the issue, when something is given to us that the labor lawyers are happy with, we immediately raise the problems from an immigration perspective. But because we're sort of playing broken telephone through our contacts at various athletic departments, we haven't had the opportunity to engage in these roundtable type conversations with all the stakeholders, all the different subject matter experts in a single location really working out the details of how do we get this done in a way that exposes the institution to the minimum amount of risk. And I think that's what needs to be happening, right? Is that every institution needs to have a team, and that team needs to be talking to each other. And that's one of the challenges, as I understand it, with sort of the bureaucracy of athletics administration, particularly in some of the larger institutions, is very often the conversations that are happening at the AD level are sort of separate from the conversations that are happening at the GC's office. And, and those folks need to come to the table together with these specialists to really throw some ideas out there. I'm not saying that, we've covered every possible scenario. This is just, kind of a summary of what I've heard out there and, and what we think of it. And I think, the bottom line is there's still a lot more thinking about the issue that needs to be done to get us to a place of, comfortable compliance, or at least a level where the risk is just not so overwhelming that, to Amy's point, the institution just says, we can't tolerate the cost of this. We're going to go ahead and cut all of our international students from the roster. And, but that's my gloom and doom scenario as a industry practitioner. Professor Weber, the more reasoned and level-headed academic, what do you have to say about this?
I was gonna say, I think I can top you. I can make it more gloomy and doomy because we haven't even talked yet about the Johnson versus NCAA case, where athletes are claiming the right to seek minimum wages under the FLSA. And that was remanded by the Third Circuit this past summer back down to the district court. They just filed their third amended complaint. The other side has until, I think, early February of 2025 to respond. But essentially, if the athletes win that case and they are deemed to be employees for FLSA purposes, the NCAA's attempt to call these direct compensation payments NIL payments really comes apart, because then this fiction that we're trying to sustain and say, well, this is not really pay for play, it's not really employment. If that decision comes down the wrong way, right then we have direct employer-employee relationships among the universities and those athletes, and things just get much messier. And it feels to me like throughout this entire House litigation settlement posture that the parties are just hoping that their NIL framework is what's going to take, and that there won't be this other card that will topple the entire house. And sorry, it's a bad pun. It wasn't intended. But that's what they're worried about, because they're trying to dress this up as not compensation. And that only works so long as enough people keep believing it. And all of a sudden you have one major court case go against you, and everything that was underpinning this NIL compensation, I think, just falls apart.
I think some level of flexibility that, you could achieve sort of within the existing legal framework, and certainly, not a universal fix. We've talked about it before. We've talked about it in some of the earlier sessions. But I think as these issues develop and as we potentially approach this gloom and doom worst case scenario of they are in fact designated as employees and much faster than anyone expected them to do so, I think one of the things that universities can do to get ahead of that issue right now is to be looking at their rosters for anyone they can switch to OP and EB1 visas, any other sort of work authorized status. Those are statuses that are tied to athletic performance, but there may be situations where an athlete might be able to have employment authorization through some other means, right? As the spouse of somebody, or through different immigration categories. So I think independent immigration analysis on every athlete to see if there is an avenue for them to obtain employment authorization ahead of what's coming is probably prudent. And that's an exercise that schools can undertake now as they know sort of what those rosters are going to look like going forward. Amy, what are your thoughts on this? Anything else to add? No? Okay. On that very fine and very upbeat note, I think we've sort of concluded our thoughts on this session, and we look forward to bringing you one last one that we'll hope to drag some athletic folks into our session here and get their perspective on things, and and really close on that note, because they are the most important stakeholders in the industry. They're the ones that are closest to the issue, and we certainly love to hear from them and their thoughts and ideas going forward. But Wayne, I think for this one, we are all done. Thank you very much.
Well,
And can I just say at the end, David, you're a ray of sunshine in my life. Thanks for that last comment.
Hey, no problem. I'm here to help.
Normally David's it really is the ray of sunshine, measured, like Ksenia said, etc. And I'm just sad now.
Sorry, wasn't my intention.
well, I have to tell you, as the kind of the outsider in all of this, the more I learn, you never leave me disappointed. I'm terrified at the end of every one of these sessions. So this is just not good. So I hope if anything comes out of all of these sessions together, somebody looks at them and realizes that there's a problem. So, but again, Ksenia, thank you for leaving me terrified one more day.
Thank you.
Take care, everyone. Thank you again.
Bye. Thank you.